Good morning. Good morning, Joe. Nice to see you again. We're live with the Light on Suitability podcast. And I wanted to speak today. Good morning to everyone. Thank you for the emails that I received, the nice emails and things like that. I wanted to talk today about a very complicated topic, a very, very complicated topic, a very controversial topic. In spite of the fact there is law stating that it's not that complicated, but it gets complicated. Number one, because we have commissioners that aren't lawyers. We have commissioners that I won't say don't care. They just don't understand how the law works with respect to the issue. And in particular, if you don't bring it up, they're not going to understand. So, and that's not a dig on the commissioners. It's just you have a new commissioner. He's a brand new commissioner. He's been a business lawyer, and the governor appoints the business lawyer to do parole hearings, and that's that. Or you have prosecutors, and prosecutors just don't believe people who have been committed with crimes. It's just in their nature. We have former gang unit investigators. They just find it really hard. But you need to, as attorneys or family members, if your client is, or loved ones, I'm sorry, or client is saying, look, I did not commit this crime. Let's use the one I always use. I didn't commit this crime. I'm coming to the parole hearing. But my friends on the yard, they told me I have to admit the crime or I won't be found suitable for parole. Not true. However, a lot of times there's circumstances surrounding it that will perhaps create some accountability for you anyway. So for instance, you're a gang member, and as a gang, we act as a collective. As a collective, we say, if you shoot at us, we're going to shoot at you. So that collective mentality, that aiding and abetting. In the past, it was natural and probable consequences of just being a gang member. And the fact of the matter is that, just by your participation, I'm talking about parole philosophy. I'm not talking about trial stuff. So any trial lawyers that might hear me might just drop over and think I'm just really don't know what I'm talking about. But in parole, you're trying to build accountability. So how do you build accountability if you and I, Joe, are driving around looking for rivals to shoot, and I shoot them, and we're both wearing a black hat, and I get identified as the driver and you get identified as the shooter, and I go to prison and nothing gets sorted out, or I'm a gang member, so you don't speak up, or I don't speak up, or whatever happens. And then here I am, or you sit in jail for 25 to life when really I did the shooting. Even though back then that was enough to get a second-degree murder conviction or a first-degree murder conviction, depending on what the prosecutor could prove was our intent, the mens rea element and all of that. I lost my train of thought, but anyway, even though that's a different matter, so you're guilty of something, certainly aiding and abetting, because you drove someone into rival gang territory to make sure that the crime happened. You slowed down, you pointed them out, you aimed your weapon, all of that happened. And then you're sitting in front with your parole attorney going, but I wasn't the shooter. So what should I say? Should I say I was the shooter? Because my friends all said, I got to say I'm the shooter or I'm not going to be found suitable for parole. And that's not true. But you have to come to the Board of Parole hearings with your accountability saying, however, if I had not been driving, if I had not been a gang member, if I had not slowed down, if I could have said, nah, this is a bad day for it. I could have done all kinds of different things. And because of me, this crime still happened. So it doesn't matter who pulled the trigger. It's just like I pulled the trigger because I aided and abetted my friend who I knew had a weapon. I knew it was loaded. We're gang members. We know weapons are used. Drive-bys occur. I knew all that. I can't feign ignorance about that. We're both intoxicated. We're idiots. We're 18. And if you just build your accountability around that, you'll be fine. That's a really easy example. As you and I both know, Joe, that's a no-brainer in some cases. The reason why I feel so emboldened to say to my clients, number one, I can't advise you to admit guilt if you're telling me that's a lie. Why? Because then I'm indirectly suborning perjury, even though I won't be asking the questions. I can't advise you to lie. I can't coach you to lie. Whatever you say in your board hearing is your business, but I am going to advise you throughout the process that I am not going to put my license on the line by telling you to lie about the crime. When I have a lot of law, I have the California Supreme Court and some very good district courts behind me to back me up. And those cases, if you as a loved one run into a lawyer who says, no, you just have to lie to be found suitable for parole, which is what you're saying. If you're saying, just regurgitate the probation officer's report. If you have a lawyer like that, you really need to think about these cases and ask that lawyer to look these cases up or rethink what the people on the yard are saying. Because I have had clients who say, okay, I did it. When he was the lookout, he told me he was the lookout the whole time. His friend went in and shot up grandma, unfortunately, inside the house, which was not their plan. Of course, it's never the plan when you're 17 or 18 or whatever. It's never the plan. Then he comes out and he was like, what happened? I shot grandma. Like, what the F? What do you mean? That was not the plan. Well, you knew I had a gun. But anyway, and then for whatever reason, your client, my client, your loved one was the one that got swept up by the police, questioned, pressured to say something or whatever happened. You get convicted, you're in trouble 25 years later or whatever it is. You're in front of the panel and they're saying, why'd you shoot grandma? And my client started to try to explain it, and he had no violent criminal history. All his stuff was always the aider and abetter of a more broad, someone was always doing the shooting. He was always the lookout. He was always the facilitator of something, and he was just a minor player in the gang. And very difficult. It was very difficult, but you have to go in with courage to say, I knew my friend had the gun. I'd seen him with weapons before. He went in there. It's still dangerous. If grandma does something sudden or he gets nervous or he panics, looking back, which you're allowed to do, and that's called insight into it, saying, things would be different. Things would be different. I would not have agreed to that. Or I did agree to it. I agreed to it knowing that would happen. And that's because I was a creep. I was a thug. And that's insight. It's a lot more than that. But Joe, there's a lot to this issue. And I want to stop talking for a minute so I can give you a chance to get a word in edgewise.
Sure. Well, a couple things. You mentioned attorneys who tell their client to say anything less than the truth. They don't really have a lawyer. They have a shyster. But, that's malpractice, telling somebody to lie. So if an inmate or incarcerated person is claiming innocence, under the law, first of all, that's it's okay. You don't have to accept or tell them that, I did it. But having said that, they're going to say, well, you're in denial. You don't have insight. There's a number of things. In Ray, I can't remember that case now. It's from like 2011, 2012. I'd have
The
to look it
Supreme
up.
Court,
Yeah.
Shaputis.
Thank you. Thank you.
Mhm.
So they're gonna in the denial, they're gonna be telling you, well, you are denied because you're in denial.
Well, they may, unless you have an attorney that holds their feet to the fire and says you'll be violating the penal code, the Supreme Court holding in Shaputis, and all the district courts that have said you can't deny parole just because they admit guilt to the crime.
Of course, but as a practical matter, the commissioners will find other reasons.
They may or may not. They may or may not. But
Well,
that's why you've got to have a very experienced lawyer to come in and tell these commissioners that, number one, and you've got to have everything else in
absolutely.
place. You've got to have a good prison record, i.e. institutional behavior is spotless. You've got to have self-help programming to help you with all of the stuff that you were doing.
Of
You've
course.
got to have all this other, you've got to have the books. You have to have everything else that you would have needed if you had committed the crime the way they say you did. And then when you say, but I didn't do this, I did all this other stuff for the gang all the time. My turn was coming anyway.
Mm-hmm.
And I just happened to get rounded up with the usual suspects, and here I am. But I was participating in such a manner that my life was in that trajectory anyway.
Yes,
You have to, it's critical. If you
that's
just
right.
go in saying, I'm going to be denied because I'm not going to admit the crime,
No,
maybe.
your lifestyle set the stage for you to be there at that moment when that happened. And if you hadn't been involved in all that stuff, it wouldn't have happened. So whoever you were, you put yourself there that that caused you to be convicted and to come to prison, basically.
Yes. So it's critical, so critical. If you don't have a good lawyer behind you to back you up. Now, the Supreme Court has said it needs to be plausible. It needs to be plausible.
Mm-hmm.
On the
Yes.
other hand, in a footnote, it says also, though, after years of the footnote and combining with some other parts of the opinion, after years of maintaining your innocence and all of the other stuff, it's not reasonable or current to say that they pose a risk of danger to the community because they won't say they admitted the crime. But there's usually a way you can work with your lawyer to develop a narrative that sheds light on why you are accountable.
That's right.
And it's critical because, like I was saying about the guy, so that kid, he said, okay, I shot her. I shot the grandma. I shot grandma in the house. I wasn't the lookout. And then the follow-up questions came. And he didn't have the answers to the follow-up questions because he wasn't a violent person. That wasn't the nature of his risk factors. He was part of a crime. He was a follower. He was out of work. So he had character defects of being lazy, of low self-esteem, all kinds of different things. And they knew it. They knew he had lied because what happened in Ray Swanigan? Ray Swanigan said, okay, I did it. You want me to say I did it to get paroled? Okay, I did it. And then the follow-up questions came. And then he took a break with his lawyer. And the lawyer said, just tell the truth. Just tell the truth. If they don't want to follow the law, we'll go to the court and tell them the panel is not following the law. And that's exactly what they did. They came back. He said, I can't say I did it because I didn't do it. I don't have insight behind doing it, which is why it's difficult to just go with, your friends on the yard saying, just say you did it. Or a commissioner who's misapprehends the law that needs you to say, just say you did it. Okay. or just agree with the official version. And when my client didn't have the facts to support the insight behind why he went in there and fired off on grandma when grandma was giving him the stuff, his friend the stuff, or he didn't know. And then it started to get it snowballed on him. And they said, you're lying about something. We don't know what it is, but nothing makes sense. It didn't make sense because he wasn't in the house.
Mm-hmm.
He wasn't in the house.
Yeah.
He didn't need to lie. He had a lawyer, me, who was going to back him up. But he went with his friends on the yard and he got denied 5 years because something wasn't adding up and he was trying to lie to be found suitable for parole. That's criminal thinking. What happened in Swanigan? They came back. The guy said, I'm not going to lie. I didn't do it. You're pressuring me to do it. And the court in Swanigan said, you know what? Stop doing this, commissioners. You can't make the guy lie to be found suitable for parole, especially in the face of facts that make it plausible that he might be telling the truth. And what the commissioners think is, oh, well, we're not here to retry the case. That's also a misapprehension. You're right. You're not here to retry the case.
Yeah.
That will end up in reversing the conviction. That's true.
Mm-hmm.
That's true. The findings are the findings. The findings are you were guilty as whatever the jury said, but the jury is only beyond a reasonable doubt. Okay, fine. That's not what we're here to do. We're making findings now about whether this is plausible or not.
Mm-hmm.
And if it's not plausible, does that implausibility have a nexus to current and unreasonable risk of danger to the community? I just got a guy granted parole after 40 years. They kept saying he participated in actually killing these girls, which he never did. And we combed through the records and we found where the girls had been, unfortunately, brutally murdered, like brutally, not with one gunshot, brutally murdered. And we don't need to go into the facts. Okay. My client was the follower. My client had been lying through the years that he had just left the scene and he didn't know what happened. And that's what he was saying.
Mm-hmm.
I uncovered that wasn't true, but the facts also uncovered that he had not committed the murder. Why? Because he didn't have a speck of blood on him. He didn't have a speck of blood on him. The bloody blood bath it was. He didn't have a speck of blood on him. Granted parole after 40 years.
Wow.
Okay. But he had to come to grips with some things that he had not been admitting. He was present. He didn't say anything. He felt guilty for not protecting them and whatever. But we developed a narrative around that. And that was how that worked out. I don't want to say too much about that, but.
Right. That narrative, did you submit any was there any documentary evidence that you were able to submit?
Yes.
Okay.
We combed through because it's a 40-year central file. So there was all kinds of very faded police reports and things. And we combed through. To be honest,
Mm-hmm.
I had my secretary combing through it and finding stuff. And then we talked about it for a long time. We talked about it week after week after week. And she said, something doesn't add up. The body was supposedly here. And he said he drove her there and that happened and this happened. And so I was able to confront my client and say, I know you didn't kill these girls, but something's fishy with the rest of your story. I'm just not buying it. You weren't driving around for an hour just trying to find a liquor store. That wasn't it. That wasn't it. And I said, just come clean. But it took a lot. And I just finally I had to come to Jesus with him a week before his hearing. I said, I think I figured out what happened, kind of, but there's still some details that were weird.
Mm-hmm.
The person that did do it was dead and he was a creep and everything else. And my client had not disclosed what actually happened to these girls, and he knew what happened. And he didn't take any steps to prevent their murders, which actually makes you guilty of second-degree murder under the jury instructions. So there's a way to do this, but you need I'm not bragging or whatever. It's been an issue for me since I started this, that when there's law here, you have to dig and you have to work with your client. So I wrote him. I also interviewed a witness. I paid out of pocket because he was a state appointed client. I don't care. It wasn't that much money. I wanted to interview somebody, and I'm like, he's indigent. So we interviewed someone, and she had said some things too that tipped me off, that he wasn't being honest with me, hadn't been fully honest with the board. He kind of would give them little snippets here and little snippets there. And then he'd sort of lie about this and then snippets there and whatever. But he would never say he murdered the girls. And I believed him on that. But I didn't believe him on some other stuff, that he had made up this elaborate story thinking he needed to protect himself from being found that he was the murderer, which it was completely implausible. He would have been covered in blood, and he wasn't. But
Sure.
That was tricky. Fortunately, I did have a good commissioner, and I was prepared to go to the court and file a habeas, which is not that hard. It's a 6-page form. You fill it out, you put the facts in there, and you send it off. And then when the trial court does their idiot, nothing summary denial when they're not supposed to, then you just go to the district court, and the district court will, in most cases, follow the law. If you have even a semblance of anything, you can type it up for your client to file it in pro per if you want, or you can just do it. It's not that hard. I know it takes a couple of little extra effort on the part of the attorney and the client. You've got to work with the clients. Unfortunately, the clients lose all their trial records. Sometimes they don't. I have one that I'm going to be working on for a guy this weekend, maybe. I don't know. So getting to your question, I went to the prison. He had a stack. He had all of his trial records.
Wow.
He even had some of the police reports, and he showed me everywhere that I could point to with credibility, not just stupid stuff that they say, whatever. You have to kind of comb through it, that says, yeah, this is plausible. I believe you. So I put together a brief to let them know, coming in for his 10-day packet, that I'm coming in saying he's not admitting to this, or this. But we have enough of a narrative that we can build accountability for some of the other stuff that happened. So in this case, he's saying, I don't agree with a couple of particular counts. He had several counts. I agree with these counts. I agree my life was off track. I agree I was doing a bunch of stuff I shouldn't have been doing. Drugs, alcohol, the usual stuff. And so we can build a narrative of accountability and insight around the stuff he is saying that he was doing, and a narrative around the stuff that was said he was doing. He put himself in a position to begin with for the victim to say that about him anyway, because, he was just living that kind of lifestyle, as we say. So it is, I'm going to keep going back to this. You must not acquiesce to this notion that the commissioners are going to not grant you parole, unless it's completely implausible because you're a narcissist and you truly are just not admitting guilt. So sometimes I've seen a record and I'm like, I can't get past it. I don't believe him. But McCoy v. Louisiana says, that's a United States Supreme Court he's the leader of the show here. He controls the destination of the ship. So if he wants me to argue, commissioners, you can't find him guilty if he's not suitable. And in that case, I argue the little footnote from Shaputis that says, even if it's implausible, you don't have to deny parole. you could look to other things because it's not a check the box thing. But definitely hold the feet to the commissioner's feet to the fire on this issue, because there you have a lot of support. You have a lot of times they'll have a record. If you just talk to your client and dissect all the facts, you can find something that's even just remaining in the record. Like sometimes you'll have the appellate case. Sometimes all I've had is the appellate record itself. The client didn't have a lot of transcripts. I only had what I had that was in the central file. I go, even using this, it says, look, they presented a defense of an alibi. It doesn't matter that the jury didn't believe him or whatever, that he didn't have an alibi. You can go over to say, okay, but the reason why I argue that is because the jury they only have to rely on one witness to find you guilty. The jury instruction says, hey, jury, if you have 10 witnesses, one says, gives you evidence that he's guilty, and 9 says that he's not guilty, you can find him guilty based on one witness. So all of these things are really important. And I just think that the majority of attorneys that represent clients don't know this. So they can't tell these guys that come to you and go, well, my friends on the yard said, well, the word on the street is, well, this guy got denied because he didn't admit the crime. I go, well, let me look at the record, because it's easy for them to say you didn't admit guilt, I'm denying you parole, but they're usually going to have another dozen reasons. You will never find an opinion that isn't subject to being overturned by the panel that we're denying you parole only because you won't admit the crime. You will very, very rarely find that.
Wait, what are you saying? That you would very rarely find that you'll be denied because you didn't admit the crime?
Only because you didn't admit the crime.
Oh, sure. They're always going to find other reasons, and they're very good at doing that.
But they can only go so far with it. If they start saying you have no insight, then you have cases to back you up there to say it's ridiculous. He's got a ton of insight. And they can't say we're denying you because you don't have insight because you didn't admit the crime. That's
Right.
specifically in Ray Shaputis. That's specifically in Ray Swanigan, in Ray Perez, in Ray Juarez, I think it is. I can't remember. In Ray Stone Road. There's
One
the
of the
cases
problems,
to
no, I
back you
believe
up.
in Shaputis too, there's the thing about that kind of nullified a lot of things about Shaputis 1, where you don't have to admit. I believe Shaputis 2 says that if you don't talk about the crime and you don't have insight, that can go to a denial if you don't talk about it.
That's really important. That's a really important distinction. It is trickier because you do have a right not to speak about the crime. You do have a right not to go to your hearing and have a decision decided in your absence. You do have a right to answer some questions and on other questions. That's a trickier little, I don't want to use a derogatory term, but the term that comes to mind is game at this point to play with. I'm not going to talk about the crime unless you can look at the case and really say there's nothing more to be said. I've said I didn't commit the crime, so I stipulate to the finding that I was found guilty for the murder, but I'm not admitting the facts. Again, you're going to get commissioners that just misapprehend the law. Do not let that dissuade you from going to your hearing and presenting your case and your narrative in the manner in which fits your life, circumstances, the crime, because there are commissioners that know how to follow the law. They're looking for something from you. They're looking from some humility or they're looking for a very strong presentation from the attorney. I do it up front. Like I say, I file that brief. So on the weekend, it's already out there as a, hey, here it is. So
Yes.
don't,
And if I may say,
I don't want to start sparring with them during the hearing. I just want to
no,
lay it out in front. This is what we're doing. We're going to
exactly.
present him as a suitable candidate with all the other stuff. He's got insight into his drugs and alcohol. He's got insight into his gang activity. He's got insight into his blah, 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 blah.
Mm-hmm. Okay.
We're just not giving you this one little piece, and who cares? It's irrelevant at this point. He's
Yes.
not dangerous.
If you can, the brief for plausible deniability, if you can get any documentary evidence that supports your claim of innocence and submit that into the 10-day package, that'll really help. I had a client who
100%. Yeah.
yeah, I had a client who was accused of it was a tough case. He was accused of molesting his stepdaughters, and for a good part of the period that he was accused of molesting, he didn't even live. He lived up north, I believe, in the state of Washington or Oregon, and thankfully he had some I don't know, gas or electric bills still. So we submitted that he lived there at this time. I think he also had we also had the landlord-tenant agreement or something showing the dates that he in fact lived there. And we had other things too. They found some pornography at his house, at the time he got arrested, and we submitted something from somebody else who lived at that house who said that pornography had been his as opposed to the client who was accused. And there were other things too, and I submitted it as a package. He had denied. I had represented him as the first time, and they were very. They didn't believe his story of denial. And then the second time, he was consistent on what he said at the first hearing, and he was granted the second time.
No.
But there were other things that figured in as well. He had, very few write-ups. In fact, I think he had no write-ups,
None.
maybe
Right.
one. His criminal record, he had like one or two minor misdemeanors. I'm not minimizing, by the way.
Yeah. And you know what you could do is you have them take a class in deniability just in case.
Yeah.
The commissioners will say, well, you haven't really even explored whether, you're in denial or not. So you have them take the class in deniability. Go, yeah, I totally understand that. I just, I'm not the guy. Or sometimes I've had it. The guy says, I'm not the guy. Took me a long time. You have commissioners that have the courage to do it in the face of an inmate who's very lengthy period of institutional good behavior. And like you're saying, he had to, a lot of times you're not going to go in there on the first hearing and go, I didn't do it.
Correct.
Unfortunately, you're going to be tested on it because the cases say he's maintained his innocence. Now,
exactly. That's what I tell them. I say, don't expect to be granted parole on the first try, because they want to see consistency of them sticking to their story consistently throughout.
Yeah.
And then I think the commissioners take pause and say, hey, you know what? Maybe we can't use that as a reason.
Because they know, they're told by other attorneys and people in the yard, just regurgitate the facts of the case.
Sure.
And the other thing is, if he's, sometimes you're going to get tricky cases. There's tricky cases where it's like, my guy gave 3 different stories to the police under interrogation. Well, that can be explained. Police are they're designed to do the job that they're designed to do, and they're allowed to do it in some very creative ways. I don't want to be disparaging to them,
No,
but
no.
they're allowed to do it that way. And so you get under pressure. You're 17, 18, 20, you're under the influence of drugs. They keep you up all night, and you just say, okay, I did it. Or at
Yeah.
first you're scared because of something something happened, or you're scared to get in trouble. So then you start lying, and then you change it, and then you lie, and then you change it again. And there's 3 different stories. So the DA is going to capitalize on that. And then you try and fix it, and it gets muddied through several hearings. And so then you don't have a consistent story. And so it's just better to go in knowing that this is a more difficult situation, but it is not impossible to be found suitable for parole if you don't admit guilt. It just has to be done right. Now, sometimes you're just going to run smack dab into a commissioner who does not follow the law and who is not going to grant parole. That's true. And you're going to find a commissioner who will if you couldn't name a single case that you could remember who they granted to a sex offender. You can't find a single case where they granted to a baby killer or whatever. And they're just like that. It's just human nature. And you just have to go back, and then you will run into the commissioner that will test you. And it will be a difficult hearing, because they're going to ask you, but what about this guy who said that? And what about that who said that? And what about this? And the court said, and they go, oh, well, you were found guilty, so you're guilty. So whatever else you say, it's implausible. And it's just like, I don't want to get off saying disparaging things, but then I just say in my mind, you're just an idiot. But anyway.
Well, and you know what?
Our clients, sometimes they lie to us, but back to McCoy v. Louisiana, the United States Supreme Court says, if they want you to argue PC 5011, then you argue PC 5011 using the facts that you have. And maybe it's just, he maintains his innocence. That's the fact that I have. That's the fact that makes it meritorious. It's not frivolous, because the law says even with implausibility, they can find you suitable. But the problem that we have, and you know this too, is I have the innocence claim. I have a great, I didn't do it, in re Shaputis, in re Swanigan argument that I could make. But then he's got all this other stuff he hasn't worked on, or she, because they've put all their eggs in this. I can't figure out this, if I should admit guilt or not admit guilt or whatever. And they haven't worked on all this other stuff. They're still gang involved in the prison. They're still committing misconduct. They're not getting self-helps to work on it.
That's the fast way to being denied.
And then you get the attorney that says, don't worry, that's the least of my concerns. You don't have any substance abuse programming. So I can go in there and make this great argument. And sometimes you do. You go in and you say, I'm just going to focus, commissioners, on this issue. I'm not going to speak about substance abuse, lack of programming. I'm not going to speak about the RVRs that he's got. I'm not going there. I only have 10 minutes. I'm going to focus on trying to make the record for the next attorney that comes in line for the client, so that they at least say, they can, be emboldened to say, okay, he didn't do this crime, and now he's fixed this other thing, commissioner. He's got self-help, and he can slowly chip his way up to a grant of parole in spite of the not admitting guilt.
The most important thing, I believe, is to establish credibility for them in all the other categories, like hopefully they've been discipline free for an extended period of time. Hopefully they've been programming and involved in, as they say, institutional activity that show an enhanced ability to function within the law upon release,
Exactly.
all that stuff.
Exactly.
Yeah, because it all comes together. It's all pieces of the puzzle that have to be, demonstrated.
And you could build your accountability around your rap sheet, around a prior crime, around prison misconduct. And you're willing to come in here and say, I did this and this and this. Oh, and by the way, you didn't know about this, commissioners. I did 3 robberies that I got away with, and I did this and this and this, and I did that. But you say you didn't commit the life crime. Why? Why would you self-report all this other negative stuff then? That builds credibility as well.
Yes, absolutely. And you need all of that because, it's like the saying goes that if you're honest about the one thing you're denying, um, and you accept responsibility for everything else that's true, they're going to more likely believe you when you deny something. It's the person that comes in and denies doing everything. Oh, I got written up, but it wasn't my fault. The correction officer, was against me,
If
or
everyone is like that, it's,
yeah,
I've had clients like that. I didn't do the life crime. I didn't do everything in my rap sheet, and I never commit all these 115s. The officer was against me. I got written up. It was totally unfair.
yeah,
That is tricky. I'm not saying there's not tricky cases, but in no way should anybody be, just saying, I have to regurgitate the probation officer's report to be found suitable for parole. That's just bad, bad advice because
absolutely, yeah.
of the
Mhm.
reasons that I said before, like it can backfire on you and whatever. It's not necessary. It's not necessary. Just tell them who you are, be humble, make a good presentation, be a good inmate. I'm sorry if you truly are innocent of the crime. I've had gang members say it didn't matter because, my time was coming, like I said, and I was going to shoot at some people because that's the nature of gang activity. If you get away with stuff, you keep going. You just keep going. So I would be in here, and I encouraged it, or I did this, or I did that. And I use the gang thing because it's easier, but there are more difficult cases, and you are going to run into commissioners that misapprehend the law or just won't follow the law.
Yes. Hmm.
And
Absolutely.
then
And
that's why you have the trial court and the appellate courts.
yeah.
So thank you. I know, Joe, you need to leave by 11. I'm going to keep my word. Keep my word. Any last minute thoughts? What's going on next week? Anything good?
Yeah, I have like I don't know, like 10 hearings coming up this week at
Oh, wow.
Saturday. I don't know if it's 10. I think it, might be 7. But, it's the usual mix of some people should not go for recent write-ups. At
But they
least,
want to go.
yeah, they want to go. I know they have a right to go, but they're looking, I think, at a 5-year denial for recent write-ups, and
But
you know,
sometimes sometimes going can be good too because they get the experience
oh
if
yeah,
they need the experience. And sometimes those year waivers can really add to your the distance between you being in prison and being out of prison. So you always have to do the flow chart anyway.
yes, it's a balancing act,
Yeah.
and besides, if it's like an initial hearing, they'll get the experience of having gone and seeing what they're up against. It becomes reality for them, and unfortunately, if it's a 5-year denial instead of a 3-year denial, that's a big reality.
It's
But then
tricky. It's tricky.
if they're
Yeah,
if
especially if
they're
they're one
sincere, they
that's
can do the petition to advance.
except they have to know if you're somebody who just can't stay out of trouble, you're gonna do that whole 5 years then because you're gonna have an intervening right in. So it's tricky. If
It
he's
is.
truly or she's truly turned the corner and think they can stay discipline free, then fine. Take the 5 and petition to advance in 2 years or whatever. It's not a set
Mhm.
number when you
Right.
can get yourself together
Mhm.
and you can make it happen. Sometimes the hearing is a benefit. It depends on the commissioner too. If you're just going to get like a short shrift, like they're just going to talk only about the write-up and not give you the benefit of a full hearing,
Oh,
then
yeah.
that's a problem. But
Yes.
then that's just a reason for somebody to mention that to somebody higher up that the commissioners aren't doing their job. But that's certainly not my job to police the commissioners, but
Right.
only when I have to, as ethical obligation to my client to make sure the law is followed. But
Sure. Mhm.
um, let's wrap it up. See you next week. Anything? That's a nice topic, though. When to waive, stipulate, and postpone. A lot of families, because we have a lot of clients saying, oh, well, I got to talk to mom before I
Hmm.
stipulate, postpone, or waive, and then mostly waive, sorry, waive or stipulate. It's like,
Yeah.
well, mom, she doesn't really understand. Oh, your sister, they don't really, you're not maybe painting the whole picture. Well, they just want me to go. It's like, well, okay,
Yeah,
that's
they'll
tricky.
say, "Oh, he's been down 20 years and it's about time he came home," without looking at anything else. They just look at the amount of time that
Mm-hmm.
their son or daughter has served, and you know, it's obviously goes way beyond that.
It's a good topic. Maybe we'll do it. I thank
Okay.
you so much, Joe. Get
No.
well. Have a wonderful
Oh, I
day,
am. You too. All of the above,
and
please.
we'll chat soon. See you next week, hopefully.
Okay. Sounds good.
Okay.
All right, Elizabeth.
Thanks,
You have a good
everybody.
one.
Thank
Okay.
you. Bye-bye.
All right. Okay. Bye.